Welcome and thank you for joining us for our webinar today. We appreciate you taking the time with all that's going on to join us and learn how to protect yourself against the unknown future. My name is Amanda Carroll and I am the Client Service Manager for Koppenbarger & Koppenbarger Law Firm. We have helped so many people in their time of need, and we pride ourselves on working as a team, not only within the firm, but also with our financial advisors and CPAs and other professionals that are instrumental in creating the best plan for you. We are the Koppenbarger & Koppenbarger firm, and we have been in business for over 40 years. We have 9 attorneys and dozens of support staff that are highly qualified and happy to serve you at any time. We have offices all over the state of California and are able to meet with you in person or through Zoom. In the chat box, you will see partner@koppenbarger.com. And if at any point during the webinar you decide that you want to schedule an appointment to come see us and discuss preventative planning, please click the link and provide us with your first and last name plus your phone number so we can reach out to you today. Your presenter today is Victoria, and she is one of the 9 attorneys within our firm. Victoria works best in estate planning and administration. She works mainly in our San Jose, Sacramento, and Santa Cruz offices, but with Zoom, she can meet with anyone, anywhere. Victoria is a hardworking attorney who knows the ins and outs of estate planning and is dedicated to protecting every client with the best of her capabilities. Here she is, Victoria.
Thank you for that introduction, Amanda. Like she said, my name is Victoria, and I am one of the attorneys with Koppenbarger & Koppenbarger. We are going to go over a lot of information today, so if you do have any questions, you can either put them in the chat or feel free to schedule an appointment with us. Let's get started. When you are planning for the future, odds are that each of these things play a role in shaping that future, and it can start to feel overwhelming. While it is such a huge blessing that we have access to unlimited information, it can also make those tasks seem daunting, and the endless information can make things more complicated. Our goal here is to not only help simplify and clarify the legal aspects, but to also help guide you in these others. Often we say we are not just lawyers, but also counselors. The things we discuss today can be very difficult conversations to have depending on where you are at in life, what you or your family have experienced, and what your biggest fears are. When you meet with us, please do not hesitate to bring up things that seem important to you, but that you may not think are relevant. Often in my organic conversations with people, I discover information that allows us to create a more comprehensive estate plan that is tailored to you and your situation. For example, just this morning, actually, I met with some clients who needed new planning set up. On our initial questionnaire, we have clients fill it out and then bring it into our meetings, and on it, we ask about occupation. But the wife had chosen to leave it blank. We got all the way to the end of the meeting, and she and her husband were discussing his retirement plan and that it was weird that she wasn't working anymore. I asked what she had done, and she told me she was a teacher, but unfortunately, she had just been laid off because of COVID. While the future seems uncertain, we want to make sure that we can do whatever is necessary to help you, and one of those things right now is also helping teachers. So if you or someone you know is a teacher, whether recently laid off because of COVID or not, please have them call us, and we will do our best to help alleviate any added stress that your estate may have caused. One of the things we're doing is offering a discount this month, so please come in if that is something that applies to you. Now, while the discount doesn't directly impact their actual planning, it does impact them. So these are conversations that allow us to ensure that we are serving you to the best of our abilities. Today, we're going to go over how to plan for families with minor children, individuals with disabilities, if you're a blended family, what are generation skipping trusts, and what about the dog? So if you're a family with minor children, the guardianship designation is one of the most intimate decisions that you're going to make. You are trying to name someone who is going to step into your place if you are no longer able to care for your children, and this may seem like a daunting or even impossible task. During our initial consultation, we'll discuss attributes that would make someone a great guardian for your children and which ones would not. During that consultation, we also discuss the difference between guardians of the estate and guardians of the person. Some people are more equipped to handle finances, while others are more capable of taking care of the children. And in some situations, these will be the exact same people, while in others, they may need to be different. The goal is that your plan is tailored to your situation and family, as there is no one way or normal way of doing things, and one size does not fit all. We're going to talk a lot about divorce today. Divorce can affect who your guardian is. If you are separated but have not initiated or completed a divorce proceeding, and you have no estate plan naming a guardian, a judge may appoint your soon-to-be ex-spouse as guardian of your child. Depending on the situation, this may not be appropriate or even safe. Further, during a divorce, a custody agreement will be reached either through mediation or through a court proceeding. Depending on that custody agreement, your ex may or may not be the person who should be documents. And it is incredibly important to ensure that your wishes, your children, are protected not only within the family court proceeding, but also within your estate plan. Again, if you don't have a plan and something happens to you, if it goes to court, the judge is who will ultimately decide, and they may appoint someone that should not be there. Now, if you are someone who has special needs and you have not named someone to take care of you, again, unfortunately, the court will. The court steps in to appoint a guardian or a protector to manage your financial affairs and even your daily life due to any physical or mental limitations that you may have. If you or someone you love is in this phase of life, emotions are likely to be pretty high. So naming who you want to take care of you and who can help get people through this is very important. Again, if you are separated but not legally divorced, it is even more imperative that you name someone, because if not, and it goes to court, they would likely name your soon-to-be ex-spouse, barring any evidence showing that he or she should not be. So with these really intimate choices, you want to make sure that your wishes are carried out, especially if a situation could be unsafe. Now, what if you're a blended family? We have something called an AB trust. What this is it's a trust that can help protect 50% of your estate in the event that a surviving spouse remarries. So an AB trust, with all of its benefits, it also has tax benefits, creditor protection, it has a lot. But today we want to focus on the benefits regarding blended families. Now, it's not looking to protect you in the event of divorce, but it can protect your children and assets in the event that the surviving spouse remarries. With the AB trust, the estate goes from one pool and splits into two pools after one of you passes away. The portion of the estate that is the decedent's goes into what's called an irrevocable trust, which means that while the survivor can benefit from the assets, no one can ultimately change the distribution of where you wanted those assets to go, and no one can take those assets away. You can also put in specific language to help protect in the event of remarriage, what we call a prenuptial clause. Essentially with that, you put in that if your now surviving spouse remarries, the new spouse would have to sign away any interest they have in the estate. And if they don't, your portion of the estate could be immediately distributed to who you wanted it to go to. We actually had a client who had lost his wife and was coming to us to update his trust. He and his wife had not set up an AB trust, and they did have children. He had since gotten remarried, and his new wife came with him to that first appointment. During the initial meeting, he outlined what his wishes were, but when he got done, his new wife asked, "Is that really what you want, honey? Shouldn't we go home and discuss it more?" He agreed, so off they went. A few months later, they came to us, and a very similar thing happened. He had a plan that still gave the majority of his estate to his children from his first wife, but again, the new wife wanted to go home to discuss that plan. Long story short, by the final meeting, he had drastically changed from the first plan to what he now wanted implemented. His new wife and her children were going to end up benefiting more from the estate than even his children were. Now, I'm not saying she acted nefariously or even had any negative intent. When you have a new family, there can be a large and honorable desire to protect the new family as well as your original family. However, was that what his first wife would have wanted? With the AB trust, we are able to protect not only what he wants in the present, but also to protect what his wife had wanted while she was alive. If this is something that's concerning to you or that you want to discuss further, please set up an appointment and we're happy to do so. When you get remarried, there are often numerous things that come into account. Remarriage is often a wonderful thing, but it can mean that there's a more complicated situation to plan for. Not in all cases, but in many. Some families want the new family to be as combined as possible, while others have the mindset of it's my kids versus your kids, and they want to keep assets and distribution separated. This can have a lot to do with age of the children and the resources brought into this new marriage. And if you have this AB trust, there may be an even more important aspect to keeping the assets separated, as we discussed on the previous slide. When you remarry, if you're bringing in separate property and children, this can lead to very complex estate planning needs, depending on whether you agree on the people named to take care of your estate when you cannot act, and if you agree on the distribution of the assets when you are both gone. So let's look at a scenario. Let's say you remarry and each of you brings a house into this new marriage and you each already have adult children. You decide to sell your home and move in with your new spouse, but the deed to that house remains in their name alone. You contribute to this home, you put in your hard-earned money, the title stays in their name alone the whole time. Now, what happens if you die? Does your new spouse's children inherit the entire house that you've contributed to? And what do your kids get? You spent what they would have inherited on that home, and maybe they even got to live in it and became emotionally attached. So how do we help ensure that both sets of children and both wishes are protected? Your plan should walk through this and address how those assets should be distributed. We had clients come in who actually had a similar situation. They had both been married before and had children from that first union. They each had community property now that they were married, but they also had separate property. He wanted things to be fairly evenly distributed between both sets of kids outside of a few assets. She was much more concerned about keeping her separate property for her children. Neither desire is better or worse, but they were different and in conflict of each other. And this we did one trust, but we had a very complex distribution plan that had to walk through almost every asset on an individual level. You may or may not need that degree of planning if you have a similar situation, but if you do, please don't worry. It can seem intimidating to even think about each asset that you have, let alone walking through where each one would go. But that's why you have us. We will walk you through, help keep you organized, and hopefully even make it a little fun. If you have a plan this complex, it may be worth doing 2 or even 3 trusts. You could each have your own trust for separate property, and you could have one that works together. You could have one just addressing separate property and one that works together. Whatever that needs to look like, we can help make happen. While having multiple trusts may seem even more daunting, having separate plans may actually simplify things. Again, this may seem overwhelming to let alone come up with a plan for, but that is why you have us. And we have no problem going over the information as many times as you need to really understand it. The separate plans may not only simplify things for distribution, but it can also help if you cannot agree on who is named. When you have a trust, you have to have what's called a trustee, someone who manages the estate. There are documents where you can keep things separate, but you have to be able to agree on the trustee. So if you can't, that's where 2 plans may be needed. We did have other clients who came into us, and it was his second marriage and he had children, and it was her first marriage and she had no kids. He wanted one of his sons named as the successor trustee, but she had some concerns that his son wouldn't want to take care of her if she became incapacitated. While there are numerous positions, like I mentioned, within your estate plan where we can name individuals in different spots for each of you, you have to agree on that trustee if you're using one trust. They did eventually come to an agreement, but you could tell it put a bit of strain on them while they were discussing this. And we don't want your estate plan to cause any strain in your relationship or for your children in the future. There are conversations that can already be incredibly emotional without adding anything extra to it. So if your situation calls for additional planning to help keep the relationship happy, let's do it. Now, another thing to note is that if you remarry and your documents do not mention your new spouse and you pass away, the court could give them what's called an intestate share. So let me kind of break that down for you. If you have one child and you pass away, your new spouse would get half of your estate and your child would receive the other half. If you have multiple children, your new spouse will receive 1/3 of your estate and your children would split the other 2/3. This may or may not be what you would want, but you should get to decide. My grandparents are actually in their second marriages, and they fall more into the category of wanting to keep assets separated. They each had adult children when they got remarried, and they had separate properties. So my grandpa chose to live in his new wife's home, but he agreed that that home would go to her son, and then his property would go to his 2 kids. Even though they are keeping their assets and distribution plans separate and laid out in 2 different trusts, it was still crucial that he made note that he was married and that he was not providing for her through the homes. Otherwise, when he passed away, she could make a claim that she should receive a portion of those properties. Now, I don't see her doing that, but that is not the case with everyone. It can be very important to make sure things are clearly laid out to reduce any chance of conflict. Our goal is to ensure that your individual situation has a plan that fits it, and the more complicated the situation, the more crucial it is to ensure that your plan is up to snuff. One of the things that we offer is what's called a generation skipping trust. This trust is designed to help ensure that your wealth stays in your family and helps protect your children's inheritance from predators, such as creditors, lawsuits, bankruptcy, or even the IRS. Now, inheritance is separate property, so long as it's actually kept separate. However, in most instances, the inheritance will become what's called commingled or mixed. What this means is that if your child divorces their current spouse and it was mixed, that inheritance would be subject to community property rules, and their soon-to-be ex could then be entitled to half of that inheritance. With the GST, as we call it, the inheritance goes into a separate trust, where it will become titled in the name of your child's lifetime trust. This creates a wall around that inheritance so that no one else can get into it, and preserves it so that in the event of divorce, that soon-to-be ex-spouse does not get any portion of it. It is also really important to note that your child can still benefit from and manage their inheritance even though it is in this specific trust. Often people hear the skipping part of the name and worry that it will skip their child. However, the skip portion comes when your child's portion passes down to your grandchildren. It skips a tax. What this means is that when your child passes away, anything left in their lifetime trust will pass to your grandchildren tax-free. So it has multiple benefits and has huge protections that only you can set up on their behalf. So if this is something you are concerned about, please come in and talk to us. All right, this is one of my favorite slides because I would say it's the cutest slide we have. To many of us, our animals are more than a pet or property. They're a member of the family. We're going to discuss how you can protect those furry family members. We discussed custody agreements for children and what that can do to guardianship designations, but what about for your pet? When a couple decides to get a divorce, who can get the dog, the cat, the bird, turtle, whatever it is, can be an incredibly emotional decision. Now, for some people, they may hear this and think we are crazy, and I do say we because my pets are very much a part of my family. In fact, the little kitten on the right-hand side is my little boy, Rocky. But for those of us who do consider our pets family, planning for them can be as important as planning for any other family member. I often hear stories of someone moving, going through a significant life change, or passing away with no plan for that animal. And the animal can end up in a shelter or even put down. The reality is that we can plan for animals more now than ever before and avoid those types of stories. Under traditional trust and estate law, pet owners could do little to make sure their animals were provided for in the event of an owner's death. So if you have sole custody of your pet when you pass away, what happens to them? Have you set up any arrangements to make sure they are provided for and cared for? Now we are in a great position to be able to provide protection for your pet. You are able to create what is called a pet trust, and that provides for the care of your animal or animals that were alive during your lifetime. Now the little one on this page is my other little kitten, Pebbles. So again, for me, I really value making sure that they're cared for in the event something happens to me. With your pet trust, you are able to name a guardian who will be responsible for caring for your animal and can set aside funds to ensure that the financial burden does not fall on the person now caring for them. Your pet trust does terminate on the death of the animal or the last surviving animal. So once they pass away, you get to decide where any remaining money goes. That could be to an animal organization. Maybe it's to that pet's caretaker. Wherever you would want, you get to decide. I had a horse for years, and she was provided for in our documents. If you know anything about horses, you know that not just anyone can care for a horse, and for those who can, the financial burden can be huge. I wanted to make sure that someone knowledgeable could care for her, and that enough funds were set aside to ensure that the level of care I wanted her to have could be. Some animals will have special medical conditions or needs, and for many of us, we more than spoil our pets, and this can get a bit expensive. So being able to leave money for the pet can relieve a huge burden off the pet's new guardian and allow your pet to continue to have the standard of care you wanted for them. If you were married and created this pet trust, your now ex-spouse may still be the person named to have your animals after you pass away. And maybe that is how you still want it. Depending how amicable the divorce was, you may have custody of the animal. But after working in family law as long as I had, I quickly found out that, unfortunately, most divorces are not amicable, and most have very hard lines drawn as to who gets what. So it is important to update your plan for your animal if you have the custody of them to match what your current wishes are. If you are concerned about who would care for your pet in the event you are unable to, or if you already have a pet trust that needs to be reviewed and want to speak to someone who understands that pets are family, please come talk to us. So we've talked a lot about planning that can be set up, but what if you have already done that and are now in the midst of a divorce or other major life change? Your estate plan should comprise of a full set of documents, all working to protect you, tailored to your situation. Whether that means providing for you, your human or furry family, a charity, religious group, whoever you care about, and whatever that looks like to you, your plan should reflect those wishes. If something slips through the cracks of one of the documents, we have multiple others right there to catch it. Our goal is to make your life, whether you are well or not, and your passing, as easy for you and your family as we can. Often you do not know the cost of an estate plan until you actually need it. Every so often, someone can get away with a very bare bones plan because those will work if nothing in your life goes wrong or changes. But unfortunately for most of us, life will throw some curveballs. If only 10% of things could go wrong, our job is to protect you from 100% because we cannot predict which 10% will happen. You want a plan to be able to protect you without having to add that protection in the midst of chaos. Now, with that said, there are changes that you need to consciously make. We have discussed divorce, and that is a big one, but there are many others. I'm going to briefly go through each of the documents that should be in your estate plan, and it is important to remember to update each of these if you go through a change and your planning no longer fits your situation. One of the biggest documents is your living trust. So a living trust is needed if your estate is greater than $166,250. The reason for that is that $166,250 is the probate limit. If you only have a will and your estate is greater than that amount, the whole thing would have to go through probate. But with your trust, you get to avoid the cost and delay of probate. It also helps protect your privacy because it doesn't have to go through court, so it all can stay within the family. You can have much greater tax planning through your trust. It avoids court-supervised guardianships or conservatorships, and it makes sure that your wishes, not the court's, are carried out. A pour-over will accompany your trust. So a trust only controls what it owns. This means that after you've established your trust, you have to make sure that your assets are titled in the trust. We go over this in depth at your signing appointment, so please come see us if that is a question. Now, if you forget to title an asset in the name of the trust, it may have to go through a minor probate proceeding. Your pour-over will is what catches that asset and chucks it into the trust. It tells the court that you have already designated where that asset should go and that it should be given back. It does have to go through a small probate, but it helps simplify things. It can cut down on time and cost and ensures that the asset ultimately goes back to your trust. Now, I just mentioned a pour-over will, and that accompanies the trust, But you may have also heard about wills in general. You need a will rather than a trust. If you are an individual with no real estate, if you have an estate of less than $166,250, and if you're the parent of a minor child. We name the guardian within either your pour-over will or your last will and testament, so either one will have those guardians named. One of the other documents is what's called a durable power of attorney or financial power of attorney. This functions while you are alive, but if you become incapacitated, it's there to help protect you. You appoint someone who is going to manage your financial or legal matters if you're unable to, and it can be revoked if you recover, or it can remain in effect as long as it is needed. One of the most important documents that we provide is an advanced healthcare directive. If you are over the age of 18, you must have a written healthcare directive. In 2004, HIPAA changed their laws to say that unless you have a written directive, no one automatically can make your medical decisions for you, which means if you don't have it, the court may need to get involved to actually appoint someone to make those medical decisions. And that may or may not be the person that you would want. We have a few scenarios where not having one can cause some catastrophic results, but one that didn't end horribly, but was still very stressful was we had a young man who he got injured and was in the hospital unconscious. His employer at the time called his mom called the hospital would not talk to her until he woke up and actually gave permission that they could talk to the mom. She was basically left in the dark. So he ultimately ended up okay. It all worked out, but that is an incredible situation that could have taken a much, I'll say, harder turn. It's something that is an easy thing to fix, and we want to make sure that you are protected in the event something goes wrong. The other piece, though, is if you have no planning and the court has to appoint someone, they have a list of who to appoint. That's your spouse, your kids, so on and so forth down your immediate family line. Now, if you are separated but not legally divorced, the court may appoint your spouse to make those medical decisions for you because you're still legally married. That may not be who you want anymore. Odds are, if you have separated from them, they really are not the person who should be making those decisions for you. But even if you are still married, your spouse may still not be the person that, and you want to stay married, let me clarify, that spouse may still not be the person who should be appointed. I have friends who do have planning and they recently got married, but one of our friends, she chose to not name her new spouse as her power of attorney for medical decisions because her husband unfortunately falls apart in hospitals. So she opted to keep her mom there. If the court had had to step in and appoint someone, they likely would have appointed her spouse, and that could have had some catastrophic results of its own if he was unable to think clearly, to even be in the hospital, to make decisions that were necessary. So again, with these so intimate decisions, we want you to make those choices. So we're here to help you. If you have an existing plan, think about when was the last time you had it reviewed, and have any major life changes occurred since it was established? Has any law changed? One of the things that happened at the end of 2019 and came into effect in 2020 was what's called the Secure Act. Now we have client seminars, and when you attend those, you're able to come in and get a free review with us. And we do recommend that you review every year if possible, but really not to let it go any longer than 3 years. We will go more into law changes at that meeting and how, when the law changes, your plan would need to change or how it protects you already. The Secure Act that I just mentioned was a big one. When it passed in 2019, it changed how long an inherited IRA can last. Rather than it being something that could possibly go on for generations, the IRA now has to be distributed within 10 years. And if it's not, there can be a hefty penalty on the funds left at the end of that 10-year span. Your estate plan is great in the sense that once it is established, you are protected for your current situation. And if nothing ever changes in your life or in the law, then your plan likely does not need to. However, it is incredibly rare that our lives will not have at least one major shift. That could be divorce, a new child, maybe your kids become adults, you receive an inheritance, second marriage, whatever it is. If you have those shifts, your plan likely needs to shift with them. I had a client who had recently gone through a divorce and she still had minor children. She and her ex-husband had established a trust together, and she now needed to have her own documents created. Because she was so proactive in updating her plan, we were able to provide new protections based on her current circumstances before any of the potential issues we discussed today could have even had the chance to occur. Pre-planning allows us to take care of your needs without the stress and urgency that a problem can create. I would rather you come in too frequently to have your plan reviewed and for you to be reassured you are still protected than to wait for a problem. While we can absolutely help you if you do wait until something has gone wrong, our goal is to avoid these problem areas. Now, while our focus is on your estate plan, we want to ensure that you are protected in every area of your life. I discussed at the beginning how many facets of your future planning there may be, so our goal is to help you stay organized and help guide you through each of those other areas. One of the ways we do that is to remind you to check your beneficiary accounts. If you have a beneficiary account and have gone through a divorce or other life change, you have to be sure to check and update the beneficiaries on each of these types of accounts. Beneficiary designations take priority over your trust. So even if you change the trust, that will not automatically change the beneficiaries listed on these accounts. Further, if the law changes, that may also affect who your beneficiaries are. I mentioned the Secure Act on the previous slide, and that is a huge example right now. When the law shifts, it is important to remember your plan needs to shift with it. So because of the Secure Act, we used to say that the revocable trust was a great beneficiary for those IRA accounts. But because of that shift in the Secure Act, we no longer recommend that. If you have questions on the Secure Act specifically, please check in with it, hosted by attorney Robert Galliano, titled Fight Back Against the Secure Act, Standalone Retirement Trusts. That is in a couple of weeks. If you have questions on any other beneficiary-related topics, we are happy to help within our capacity and then connect you with other professionals within our network when needed. Amidst all of this planning, I'm sure you can tell there are a ton of documents to sign and review. One thing to note is that you should have an attorney who helps walk you through your estate plan and explain what you are signing. The documents can get very overwhelming, and if you are trying to do it alone, you may not know what you're signing. If you have already signed an estate plan with another attorney and want to ensure the plan reflects your wishes and that it was properly executed, please come in and we're happy to review it at an appointment. If you signed with us, but you need a refresher on what your plan says, we would love to see you again. You need to feel comfortable that your estate plan says what it needs to, and that you're comfortable you understand it to the best of your abilities. We discussed some very personal and even emotional topics today, and it can be easier to avoid having these discussions, but we are here to help you through them. Avoiding these discussions can have huge ramifications, unfortunately, so it is our job to help make these topics more tangible and easier to digest. We want to make sure that you leave feeling not only protected, but with a peace of mind. Our lives can take very unexpected turns and can leave you feeling a little whiplashed. I mentioned at the beginning, we often act as counselors. So if you are someone who doesn't know how to start because you don't feel together enough, or that you have all the answers you think are needed, please don't let that be what keeps you from coming in. We are here to listen, counsel, serve, and guide you through each phase of life while providing estate planning protections. So thank you for listening to me today. I know that this can get overwhelming, but it is so important to have these talks, like I said. I'm going to pause for a minute and see if there were any questions put into the chat. So give me just a second to do that. Might take a minute, sorry. Okay. So it looks like the one question that we did have, I need some additional detail. So if you end up having questions, reach out to us. I'm now going to welcome back Miss Amanda.
Thank you so much, Victoria. Again, we would like to thank you all for attending our presentation today and truly hope you received valuable information that will help you plan ahead. Remember, you worked hard your entire life to build what you have, and whether that is a little or a lot, it's definitely worth protecting. If you need assistance with any of this planning, we are offering a complimentary appointment and 10% off your plan if completed by the end of the year. As a reminder, We also have financial options available. If you would like to meet with one of our experienced attorneys, such as Victoria, please click the link in the chat box, which once again is partner@copenbarger.com. We will reach out to you and schedule your consultation today. Remember, if we didn't answer your questions during the presentation, we most certainly will answer it during your complimentary appointment. Lastly, we want you to know that we are here for you through all stages of life, whether it is setting up an estate plan as a new family, creating a plan to protect a newly blended family, or helping administer an estate of someone you lost. Our founder, Lloyd Copenbarger, has always had a phrase he's used over the years. It's, if your attorney isn't there when you need them, then you don't need them. We truly take that to heart, and we'll be here when you need us. Have a great rest of your day, and thank you so much for joining us.